We're live.
Good morning. It is May 27th in Senate Judiciary. We are trying to breathe some life back into S-109, the miscellaneous judiciary bill. We have Eric Fitzpatrick with us with a amendment that would change a lot, or rather remove a lot of what the House added. And Eric, I think I'm losing Senator Norris at 9:30, is it? Yeah. And so if we're able to just get just the high level overview of the amendment, that would be great. And then we'll, since we have a quorum, we'll just take a vote on it in the near future before 9:30.
Yeah, Eric Fitzpatrick with the Office of Legislative Counsel. Thank you, Senator Hashim. And yeah, I can do a quick, go through it in 10 minutes or so, or whatever you think makes sense. And I don't need to share I can share my screen if you want, or I can just kind of touch on what the changes are and the gist of the amendment is.
Just for the folks who might be watching from other places.
Right. I missed that. Sorry. So should I share?
Yes, please.
Okay. Yeah, sure. Let's see. All right. Can everyone see my screen okay?
Yes.
Great. Okay, so yeah, as the chair was saying, this is a proposed changes to the House amendment that came over. So I'll go through real quick what they are so the committee can get a sense of them. The first one starts on page 17, and this is the firearms, recall it, surrender order compliance working group. All this does is change it back to the Senate version. The House version had taken two members of the working group, the Center for Crime Victim Services and the Vermont Council on Domestic Violence, and moved them to the consultation piece. You see them there, lines 13 and 14, page 18. So the Senate proposal was to move them back to the way you had it originally, which is to put those two parties back on as members of the working group rather than just parties to be consulted.
I think that was Senator Mahowski's suggestion. We're good with that. Thank you.
Yep.
Here's the things I suggest.
Good.
Sounds good. So that's it for that one. Then you can move forward quite a bit. These are all sections actually that were in the Senate version originally. So now we get to, as Senator Hashim was saying, a number of sections that are proposed to be removed. These two sections on page, let's see here, page 22, sections 27 and 28 having to do with the repeal of the sunset on the marriage license fee increase. That's actually already that was in the budget already and signed by the governor. So no need to have those sections here. So they're struck. Section 29 has to do with the appeal from conditions of release for, and I'll show you the actual language here that was proposed to be included. There it is, page 24, lines 6 to 8. So when a request to revoke bail is denied, and the proposal is to add the appeal procedure into the existing statute. And I think the committee's view on that was that it required more testimony, and that whether it be from both state's attorneys, defense attorneys, possibly the attorney general and the court, that there was a lot of parties that would need to weigh in on this, and that given the time constraints, there wasn't time for that yet. So the proposal is just to strike it. You can always come back to it either as its own bill or in the miscellaneous bill this coming year.
Thanks, Eric. That was one of my suggestions, and you summarized it pretty well. I just to reiterate, I think when we're talking about something as substantive as bail and appeals to the Supreme Court, that's not exactly something that should go in the miscellaneous bill and requires a fair amount of testimony. So thank you.
Sure, absolutely. So that's that one. Then we move to, this is staying in, but just a quick summary. This is section, so you remember this is Representative Emmons testified to the committee, I think last Friday on this, and this was the also a request from the Center for Crime Victim Services, and it's the idea that victims are being permitted to opt in. Crime victims can opt in to receive the same notice every 90 days that offenders can receive when they get earned time reductions. So when they have some of their term reduced through the earned time program, they have this 90-day notice provision, and this allows victims, if they choose to, it's not required, but they can choose to opt in and receive that same notice if they would like.
What page are you on, Aaron?
That is on page 25.
Thanks.
Section 30.
Yes.
So there you see line 12 there. It allows the victim to opt in and receive that notice every 90 days. And this is a related section is the next one on the next page, section 31. I think you also heard from Representative Emmons, and also that's the one that the executive director of the Center for Crime Victim Services emailed the committee about, and this is the Victim Notification System Task Force. This looks at victim notification processes generally, with the idea to try and make sure that these processes can be improved where that's possible, so that in particular some automated notification provisions can be incorporated more so than they are being now. The idea is that, there's a bunch of different places in law where victims are entitled statutorily to receive notice, whether that be for, as we just saw, whether something related to the earned time program, or whether or not their ability to come into court and make victim impact statements. There's a variety of different places where that notice is required, but there's some concern, I think, among the parties about how well that notice is being provided. So the idea is create this task force, look at this in a big picture sort of way, and then come back to the legislature. You'll see, I think it's in this year, November. That's page 27. Report by November.
Sorry to interrupt. Senator Norris has a question.
Yeah.
Good morning, Eric. On lines, I think it was 14 and 15, members appointed, whatever else. Is there any per diem that goes along with this? It's got to go to another committee again, or?
Yeah, not this one. Nope. So there was no, if I remember correctly, they did not. Yep. So no per diem in this one. So state employees, no need for that. But good point though.
Just slow the process down here.
Yeah. Right. So that's that one. And report by November, as I said. Next section is also another working group that struck. This one is the Adult Involuntary Guardianship Working Group. You may recall, this is the provision that had the probate court and a number of other interested parties studying whether or not to, consolidate these two different types of guardianship provisions that now happen in two different courts. I spoke with Judge Zoni about this, though, and the thought here is that this is something that the parties can continue to look at, and it's not as time sensitive as some of the other ones that you have in here. So again, it's another one that can be deferred until next year without having to take testimony from the various parties who might be interested, and then you can come back to it and see if they might want it again during the, say, miscellaneous bill next year, for example.
Thanks, Eric. And I'll also note that we do have a bill on the wall related to this issue, and so we'll have, if we do decide to make any changes, we'll have a vehicle in which we can take testimony and make any changes on this upcoming session.
Yep, that's right. Exactly. Thank you. So that's that one. Let's see what the next one is. That I think there's another one that's coming out. Oh, this stays in, but you may recall this is all Representative Emmons was also testifying about this issue last Friday, and this was the capital budget request. When they are made by the assistant judges, it's the procedure, the process that the court administrator has to go through to evaluate whether or not those requests, when they're related to county courthouses, should be included in the big bill each year. And what this does is just add several criteria that the court administrator will have to consider in the course of deciding whether or not to make a positive or negative recommendation about the budget request. And both the court administrator and I think the court administrator emailed as well, but both the court administrator and the assistant judges have all agreed on this language, and they're fine with doing this, provided that it does have this. You may recall it has a delayed effective date. doesn't go into effect until July 1st, 2026. So it gives them a little time to think about how they're going to include these items in the list of criteria that the court administrator takes a look at.
Eric, we do have Senator Norris' question.
Yeah, Eric, sorry to keep interrupting here. I asked
No problem.
Emmons, well, she was in here after the fact, I guess, and these are county buildings that the state doesn't want to supply any funding for, but yet for the most part, depending on where you are, 3.5 or 4.5 of the employees in there are state paid, and the state business is taken within that particular county courthouse. Is there any form of a lease agreement or whatever else? In fact, they're telling these local counties they have to absorb all this cost. Does the state pay anything for the use of those buildings?
That's an interesting question, Senator Norris. I honestly don't know the answer to that off the top of my head. I can check in. I'm sure Representative Emmons would, so I can check in with her and circle back with you. But I'm not positive about the answer to whether there's any lease payments, because you're right. The counties own the buildings, but some of the functions that go on in there are state functions. I think, again, I don't want to commit to this, but I think there are some lease payments that go between the counties and the states on that, the state rather, but I'm not sure how they work out the details of that.
Okay, well, Chair Emmons did not have that answer, and that's why I was asking you. Hopefully that you did. I'm sure the judges signed on to it. There must be some form of payment coming in. Otherwise, I understand that the reason for not wanting to use the state monies for county buildings, but 90% of the act that takes place there is pretty much state.
Right.
Well, I'm not going to hold it up for that. I just want to move the answer for it, Eric. That's all.
Yeah. Well, I will find out. It occurs to me that the court administrator might also know the answer to that. So let me also, I'll look into this just so we can get an answer for it one way or the other as you move, whether, as you say, whether or not you hang on to the bill any longer or not, I'll still get the answer.
That'd be great. Thanks, Eric.
You bet. So related to this, adding those criteria for the court administrator to think about is this report that struck on page 33. So remember I mentioned that it has a delayed effective date of July 1st. In addition to that, what had been in the House version was in the meantime, before January of 2026, the court administrator and the assistant judges were tasked with reporting back on how the implementation of these criteria was going. So I think the proposal here is keep the delayed effective date, no real need for this report, because they're going to be working on it over the next year until it goes into effect on July 1st, 2026 anyway. And they'll presumably, because of the 1 year delayed effective date, have plenty of time to work out what they need to work out to make sure it works. And if they don't, there's also plenty of time for them to come back to you next year and let you know. But either way, there's no need for a formal report. It doesn't seem like it's going to change the process that would happen either way.
Thanks, Eric. Yeah, and just to add on to this, this report can very easily just be a request sent by email to testify and provide some information back. And I don't think it's something that we need to put, into the books just to get a report back. So that was my thinking behind it.
Yeah, just ask him to come in and testify next year if you felt like you wanted an update.
Perfect.
Okay, so that piece comes out. So remember, moving on, the next couple of sections have to do with the DUI second. Remember, the idea is here the proposal was to reduce the number of hours of community service that could be performed as part of the sentence for a DUI second from 200 to 80, so that you're incentivizing the use of the community service option rather than the 60 consecutive hours of imprisonment, which is being opted much more frequently currently. So the proposal is keep that, but as it came out of the House, I'm over on page 34, section 36. As it came out of the House, it had a 3-year sunset. So it was only in effect for 3 years. The proposal is to just go ahead and repeal that. Just, again, no limitation on what the legislature can do either way. If it turns out that you hear that the reduced number of hours for community service isn't working, you can always revisit it and change it later on. No need to have a sunset in from a legal perspective. It's just a policy choice for you guys.
Thanks.
Yep. Another struck section is a recommendation about the use of family forensic evaluators that's supposed to come in from the Chief Superior Judge, the Director of the Office of Professional Regulation, and the ED of the Vermont Psychological Association. Again, I think whether or not these folks want to get together and make a recommendation, as the chair was saying, with respect to the earlier provision, not required that you have a statute on that. They can come back and make whatever suggestions they want next year if they feel like it's an issue that they want to study again. So the idea is, do you need the statutory requirement on this? And I think the proposal is to go ahead and strike it.
Thank you.
Yep. Let's see. Say similar. This is the child. I think this is the last section, section 38, Child and Parent Legal Representation Task Force. And this is the one you recall that there's a large number of members on it, but there's some different points of view about whether this is needed and whether or not it's a good policy choice to have this task force look at it at the current time. So I think it's particularly in the miscellaneous bill, you generally try and have provisions that there's consensus on, rather than having a great deal of different points of view from the advocates and from other folks who appear frequently before this committee. So I think, again, it's a proposal here is to strike that, given the fact that there's some different perspectives on whether this is the right approach toward dealing with child representation in these matters, and then wait to hear if there's maybe more specific proposals for how to approach it next year.
Thanks, Eric. And also point out, talked to Senator Norris recently, who had the recommendation of bringing this up first thing and during the Joint Justice Oversight Committee meeting when we start meeting up again in summer. And I think that's a great idea. But in the meantime, I do want to avoid creating a task force that could have a substantial financial impact and is being considered controversial. Senator Bukowski.
One of the suggestions was made to reestablish the oversight committee. Would we need to do anything by legislation to do that, or does it already exist on the books?
I think that so I was looking into that. My understanding is that it stopped meeting a few years ago, and re-implementing that group is something that I'm definitely interested in. But similar to the task force and a number of other things, I think it would take a good amount of testimony to make sure that we're establishing something with the correct charge and membership, rather than just copy and pasting what the task force previously was. But it's definitely something that I want to look at in the near future.
Okay.
So
Yeah, I think it was 2022 when it had a sunset. It was established statutorily. It's sort of a similar idea to the Joint Justice Oversight Committee. It was 6 legislators, 3 senators, 3 representatives. Met frequently during the interim for several years. I think it was maybe 2017 to 2022, or maybe 2015 it started, actually. So it would require some establishing it by statute and coming up with the language that you wanted around the committee's charge, again, as Senator Hashim was saying.
Okay, that's really helpful, because I do think that's a good idea to have that oversight of what's going on and how we're doing it and how we can best do that work. But I also recognize it's sort of the 11th hour.
Yeah. Eric, was there anything else in this?
Only just one thing I realized I forgot, so I'm just going to zip back for a moment. That takes us to the end, but there was just the one issue that you remember DCF was testifying with, along with some of the couple of private attorneys who work on the issue of past child support payments being relevant for current court proceedings. And I think that you heard you had an email from Kurt Hughes, who practices in this area, as well as a couple of other family practitioners. And DCF also has agreed with this. So they all agree on these 3 sections, which are on pages 19 and 20. And the essential gist of it is that it makes clear that in these two different types of proceedings, in this first one that you're looking at on page 20, this is not a proceeding that involves DCF or the state. So when you're talking about, these are adoption proceedings when, for example, a dispute between a custodial parent and a step parent, for example, and the step parent wants to adopt and one of the biological parent doesn't agree, the probate court has to make a decision about adoption. And it's in those situations in which someone's child support history may be relevant because it's a dispute between, say, two biological parents or a custodial parent and a step parent about who should be the proper person, whether or not adoption should go through. And that's why that language is reinstated. It was repealed last year, but I think then it became clear to the parties that in those particular types of proceedings, someone's child support history, whether they made it or whether they didn't make it, is sometimes relevant. So that language is put back in so that in those types of proceedings only, it can be considered. But then in the next two sections, 25A and 25B, this is the language that DCF provided, makes clear that child support is not relevant in situations where it's DCF, the state, in a TPR, termination of parental rights proceedings. In those cases, it's about the best interest of the child, not about whether one of the parents was up to date on their child support payments. So that was the one thing I forgot to cover in my walkthrough. But otherwise, yep, that's it.
Good. Thank you, Eric.
Yep.
Any final questions on this? Are we ready for this language as it's written? And good. Okay.
Good.
So procedural question, does this require an official roll call vote or a straw poll?
This is a Senate change to House amendment.
Yeah.
I mean, you could do it either way. Like you could get a sense of the committee and bring it to the floor and stand up but no reason since we all.
Yeah, we're gonna do a roll call, I guess.
Yeah.
Well. Thank you.
Oh, okay. We're good to go.
Good to go.
Senator, everyone hear me okay? Sorry.
Yes.
I didn't have anything to say. I just thought I had accidentally deleted my broadcast.
Yes. Senator Vihofsky,
Yes.
Senator Baruth,
Yes.
Senator Bados, yes, Senator Kashin,
Yes.
5-0. Fast.
Okay, great. Thank you. So I think this will be able to bring back the miscellaneous bill, thankfully, because there's a lot of good stuff in here. Order, and who reported this originally? Do you want me to?
If you want to take it and run with it, run with it. Yeah, I'm not gonna take offense to it.
Well, you sure? Okay, yeah, I can take it. And
I want to see a floor fight over who gets to report these amendments.
yeah, so all right, I can report the changes. I think tomorrow I can ask to have it be brought off of the the limbo.
Chris storms out.
The shipping story. And
The only thing I'd add is that that document that you have can help you with the floor report, but the actual proposal of amendment isn't going to have any highlighting in it. So I'm going to have that version proofed and edited, and then I can send it to Autumn and to you and to John Bloomer so that you have that one, which I think would go in the because you're going to be, the proposal is going to be to further amend the House proposal, and that's going to need to be a document that I can get to you.
perfect. Is tomorrow too soon, or would Thursday be better for you?
Either way is fine, whatever works for you.
Okay. We can connect offline. I know some folks have to leave, but thank you for coming in, Eric, and yeah, appreciate it.
Yeah, sure. Thank you. Appreciate it. And yeah, I'll circle back with you later about